Hi everyone, and welcome to our webinar today on the Employment Rights Act. Where are we now? It seems like everyone is talking about this topic at the moment, but we're here today to talk through the current status of the legislation, what this means to you, and share some practical tips on what you can do now to prepare. Some introductions. I am Juliet. I'm the Director of HR Operations here at Impact HR, and I'm joined by Grace Rogers today, who'll be supporting me in the background and collating all of your questions. We're using GoToWebinar to host the webinar today. So for those of you that haven't used it before, you're all muted and we can't see you, but you've got the option to type in some questions for us on this topic as we go throughout the session. So depending on whether you're using the web version or desktop version of GoToWebinar, you can find the relevant part of the app to ask these questions. As I said, Grace will collate them and we'll try to answer as many as we can at the end of the webinar. We'll be asking you some questions today as well. We've got some polls set up that we'll ask throughout the session today. So as and when we get to that section, there'll be a pop-up screen for you to choose the relevant response, and it'd be great if you could interact with us and give us your answers. So before we get started, I just wanted to take a moment to introduce Impact HR and give you a bit of background about what we do here. So at Impact HR, our focus is on delivering HR solutions that are genuinely tailored to your business. So we recognise that no two organisations are the same. So whether you're a small or a medium-sized business that you're looking to grow or scale, or if you're a larger organisation and you want to refine or to strengthen your existing HR processes, our approach is always built around your specific needs. Our services are therefore designed to be both flexible and comprehensive. So we support businesses in improving operational efficiencies, ensuring compliance with employment law, regulations, and ultimately freeing up your time so you can focus on what matters the most to you, which would be growing your business and supporting your people at the same time. So we understand that the real challenges that SMEs face when it comes to managing people, and our reputation here is built on our expertise, our practical hands-on support, and delivering real tangible results for our clients. And that support can take different forms. It might be helping you create or update essential documentation like your employment contracts or employee handbooks or policies. It might involve chairing disciplinary hearings or capability meetings, or just guiding you through more complex processes such as any redundancy or organisational change consultation processes. We want to work in a way that suits your business. So some organisations choose to work with us on a retained basis, while others prefer a pay-as-you-go or even a project-based approach. So as with all of our services, if you are looking at a retainer, we know that one size doesn't fit all. So we do tailor all of the arrangements to reflect the needs of your business. So before we get into the detail, I'd just like to briefly run through what we'll be covering in today's session and why this topic is so important at the moment for businesses, for leaders and HR professionals as well. So the Employment Rights Act represents one of the most significant sets of changes to UK employment law in recent years. For employers, these changes will have practical implications for how people are recruited, how they're managed, how they're generally supported within the workplace. And for leaders and for HR teams, understanding what is coming and preparing early will be key to avoiding that risk and ensuring your organisation remains compliant. So today's session is designed to give you a clear overview of where things currently stand and what you should be thinking about as an employer. We will look at where we are now with the Employment Rights Act and including the broader direction of travel that the government's intentions behind all of the reforms. We'll talk through what is actually changing, and some of these changes will affect core HR processes such as your contracts, your policies, your probation periods, and how certain workplace issues are handled. We'll also look at the implementation timetable because all of these changes won't all happen at once, which is really handy for us. But understanding the likely timeline will help you prioritise what needs attention now versus what can be planned in for later in the year and beyond. We will look at what these reforms mean in practice for employers, the potential implications for businesses, leadership teams and HR functions. And we'll finish with some practical actions that you can start thinking about now so that you're better prepared for the legislation and as it develops and begins to take effect. The aim of today's session then isn't just to explain the legislation, but also to help you leave with a clearer understanding of what it could mean for your organisation, excuse me, and the steps that you may want to start considering after today. So before we look at the individual changes, it's helpful to understand where we are in the process and how the implementation will unfold. And everything that we talk about today is as it stands in March 2026. So we last spoke about this topic back in November, and it was still the Employment Rights Bill at that point in time. And the first key point is that the bill has now completed the parliamentary process. It received royal assent on the 18th of December last year, which means it has officially become the Employment Rights Act 2025. However, royal assent doesn't mean that every change happens immediately. Instead, the government is introducing the reforms in stages over these couple of years. And this phased approach is designed to give employers time to prepare, review their processes, and make any adjustments that are necessary. So as we can see here, the implementation began in February 2026 when the first set of measures came into force, and these were around trade union processes. Further changes are scheduled then to follow in April 2026, October 2026, meaning that throughout this year, we will start to see the first practical impacts of the legislation, and actually in a couple of weeks' time, with it being April. Then the rollout continues into 2027 with additional measures expected as early as January 2027 and then throughout the year. Beyond that, there are further phases, but they're currently anticipated for April and October, but we are waiting to hear the confirmation on those. So what this means in practice is that while the Act is now law, the real impact for employers will emerge gradually over the next couple of years. So like I said, then for businesses, for leaders, HR teams, this phased implementation is actually really helpful. It gives us a bit of time to understand the procedures, review our policies and make those changes, just making sure that our organisations are prepared before each stage comes into force. So throughout the rest of this session, we'll highlight which changes are likely to appear in which phase, so you can start thinking about what actions might be needed and when. So I mentioned that we had a few polls then throughout this session today, and the first one is asking you, how prepared do you feel your organisation is for the changes throughout the Employment Rights Act? So if you can add your answers in there to say if you feel very prepared, somewhat prepared, not very prepared, or not at all prepared, that would be great to see. We actually asked this question in November when we did the webinar previously, and not surprisingly, a lot of the answers were not very prepared at that point, so it'd be great to see what the results are today. Okay, so I can see the results coming in then, and actually the majority of people are sitting in somewhat prepared, which is great. That's great to see. It has moved on then since we did this last November. And it pretty much is exactly where organisations are sitting at the moment. You've probably started to take some steps in making your preparations for these changes, but perhaps still a bit unclear on the finer points or maybe the timing of certain changes. So what we can do today then is clarify what is coming when, highlight the highest risk areas for you as employers and give you that clear action plan to somewhat prepared to fully prepared over the next few weeks and months. So thank you for your results. So the key changes then, so we'll talk through the major changes, but just to summarise the key changes within the Employment Rights Act, and they include unfair dismissal from 6 months of service. I think this is the most headline grabbing change that has come through the Act over the last year. Plus family friendly reforms, statutory sick pay changes, and those two we know are happening in a few weeks in April. The simplification of trade union processes, changes to 0 hours contracts and guaranteed work, restrictions to fire and rehire practices, plus changes to flexible working requests, tribunal reforms and reporting requirements, and stronger rules around sexual harassment and harassment in the workplace. So we'll be talking through some of these today. And there are lots of other topics within the Employment Rights Act, which I will talk through briefly at the end of the webinar. But obviously do get in touch if you have any queries about any of the topics that we're not covering in detail today. So another poll for you just before we begin. How confident do you feel that your organisation will be ready when the changes come into force? So not so much how prepared do you feel, but how confident do you feel that you'll be ready for these changes? And as I mentioned, some of the changes will be coming in a couple of weeks in April. So a bit more of a mixed bag on this result. We have a few saying very confident, which is great to see. A lot saying fairly confident, and also a few saying not very confident. But nobody in the not confident at all, which actually is really good. So it's extremely common then that the businesses are juggling all of this at the moment with also running the business itself. But the good news is you're in the right place, and the fact that the Employment Rights Act is being implemented over a number of months, a number of years, we've still got plenty of time to get things in order. So let's talk through the changes then and how they may affect you. So as I mentioned, the most common one that we get asked about then is the changes to unfair dismissal. So what is changing here? Employees will be protected from unfair dismissal from 6 months of employment rather than having to wait the 2-year qualifying period that it is at the moment. Plus, the compensatory award cap will be removed entirely. So currently the cap for an award for an unfair dismissal claim is set at just above 118,000. And with this being removed, it means that higher earners would face a cap on what they would win through unfair dismissal. So that is no longer going to be there. This is confirmed to take place from the 1st of January 2027. However, this will apply to employees who start employment from the 1st of July this year, as by the time they get to the 1st of January 2027, they will already have accrued their 6-month service. So as we look at what actions to take, these will need to be implemented within your organisations now to begin managing this new way of working as part of your processes, and especially new hires over the next few months. So what this means for you as employers, potentially greater risk from early termination decisions. So currently employers have that 2-year period to make a decision, and in most cases with relatively lower risk. However, that will no longer be the case, as early termination decisions nearing 6 months of service will now carry risk for the employer to consider. It's estimated that this will extend protection of unfair dismissal to around 6.3 million employees who would not have previously qualified, and the government estimates that this could increase by an extra 9,000 per year and an additional 3,000 tribunal claims per year, which is going to be really interesting to see how that pans out on an already stretched tribunal service. When the compensatory cap is removed, we also expect to see more claims being made at a higher value. So currently with the cap in place, in practice, that means that higher earners have tended to settle their claims outside of the tribunal system. But going forward, we might find that higher earners may be less inclined to negotiate, for example, through a settlement process, if they know that they have a strong claim once the compensatory cap is removed. And a really big one is probationary periods. These will become a lot more important. So now the service requirement has been set, we're no longer facing that potential mandatory probationary period that was initially suggested around that initial period of employment. That's no longer proposed. That was at the bill stage, but now it is the Act and it's landed at 6 months. This means that the probation period is going to be something that an employer can set and manage according to their own processes. So now it is something that we are urging everyone to review. For example, if your probationary periods have been set at 6 months duration up to now, we are urging you to review this because when employees reach 6 months of service and therefore they gain the right to claim unfair dismissal, making a decision around continued employment at 6 months of service will be too late to rely on that as a failed probationary period. So instead, probationary periods will need to be shorter in duration and closely managed to allow line managers the opportunity to review the suitability of their new starters accordingly in that shorter time frame. Performance management processes and documentation of that process will also become critical. So if making a termination decision, employers will need to have a strong reason to dismiss based on sufficient evidence to back up their decision as well. So actions to take now. What we're advising then is to take that step back to review your current recruitment, your selection and your onboarding processes, and ensuring that you have a robust process in place to make the right hire in the first place, with a view to reducing any need to terminate any new hires in that short space of time. We're also advising to audit your existing probation period process. So review what you have in place currently. And like we said, what is the length of your probationary period at the moment? Is it 6 months? In which case, this will need to be updated to give you time to review performance throughout the probation review and give you time to manage it or make a decision to bring employment to an end before the 6-month time frame. But we're also advising employers to review whether your managers are holding their probation reviews. Does your organisation hold probation review meetings at all? And if not, it is something then to certainly implement now, ready for this new legislation. And also update your documentation that refers to probationary periods, what the duration is and what the process is that is followed. So as we mentioned then, performance management frameworks, we are advising then to develop one if you haven't got it already, or to review any that you have in place, just to ensure that you provide a structure around the performance management process that's simple for your managers to use. One, to support and develop your people, but also two, in case you need to refer to this in any termination decisions as your evidence. Train your line managers on handling performance from day one throughout that probationary period, and this is key. It will not matter if you have the best process and the best framework in place if your managers are not trained in how to work within it sufficiently and actually follow it. So train your managers on the process for any dismissals to ensure that they are handled correctly, and ensure that your managers are trained in the process that they must follow to reduce the risk in termination decisions in terms of the process, but also documenting the process. And also ensuring then your managers can seek expert advice, for example, through us here at Impact HR, to ensure that they are following the correct steps. And a core part of our service is to provide advice to organisations to ensure compliance in these kind of situations. And finally, on this slide, I've mentioned here to foster a positive workplace culture. And really to do this to reduce the risk of claims from outgoing employees. So a lot of claims come from an employee feeling disgruntled with the way that they've been treated. And this can be reduced then by treating them fairly and respectfully when unfortunately ending employment. So as we're talking through all the updates to legislation, one of the biggest areas for employers, or the biggest risk areas for employers, is inconsistent management practices. So this is your line managers, and they're at the forefront of dealing with all of these changes in practice with your staff. And so throughout all of the updates that we're talking through, it's imperative that your line managers are aware of the changes and how to manage them. So I just wanted to add another poll here to ask you that question. Do your line managers currently receive training on employment law or people management issues? So I've got yes, regularly, or occasionally, rarely, or never. So I'm going to cast your votes. Okay, thank you. So I think the majority of the answers here are coming out occasionally and rarely. And actually, oh no, we've got 2 people that have said yes regularly, which is great for those 2, but the majority of the answers then are coming out in the middle. And that's quite a common position for many organisations. Often training happens when there's a particular issue, or when a manager first moves into a leadership role and they go through all of their initial training, but it doesn't always get refreshed. And the challenge with that then is this approach to employment law and workplace expectations, because they're changing over time. And managers then don't always feel confident or equipped in applying their training or their knowledge to different situations. So just one thing that, again, we can help with here at Impact HR is providing a structured management training program for all of the day-to-day skills and information that they would need then to manage their people. Not just around the things that are coming through the Employment Rights Act, but general day-to-day people management as well. So do get in touch if that is a need. So moving on then to the topics again. So let's look at statutory sick pay. So what is changing here? So statutory sick pay will now, from April, be payable from day one of the sickness absence. And this is now removing the first 3 waiting days, which are currently unpaid for any absence period. It's also going to remove the lower earnings limit eligibility criteria. And as happens every April, the weekly rate of statutory sick pay is also increasing to £123.25. And as I mentioned, then this is something absolutely confirmed happening on the 6th of April, so we have a couple of weeks. What this means for employers then, potentially increased costs to cover more days of absence with SSP, and potentially more short-term intermittent absences of employees perhaps taking your day off or 2 days off, because now they would benefit from an SSP payment during those first 3 days when before they would have been unpaid. So there are some actions to take now, and the first thing that we are suggesting is that you brief your payroll provider on these changes. We really hope that payroll providers have got this information already and that they've updated their systems, but it's always good to just check in and make sure that everyone's aligned with these new laws that are coming through in a couple of weeks. Also, brief your line managers on these changes and ensuring that your line managers have the training and the tools to manage their absences in the team, especially if it's potentially going to be increasing. So this may include reviewing your documentation in relation to like return to work forms, self-certificates, and reminding managers of their role when an employee is off sick. For example, keeping in contact with their employee, reviewing absence trigger points, and ensuring that their employees are actually following the absence reporting procedure correctly. So all of these tools and there's many more, but they can help manage those short-term intermittent absences. We're also advising to review current HR documentation, your policies, your contracts, absence management forms that I mentioned, just to ensure that they reflect the new rules around SSP and that they're not then out of date. And finally on here, another action then is to ensure your HR systems are up to date with absence reporting. And again, that your managers know how to log an absence, how to monitor it, just to ensure it doesn't go by unnoticed or forgotten, which can potentially open the door for employees to take advantage of a weak absence management system. So that is the changes to SSP. So moving on to another update coming in April are family-friendly reforms. So what's changing here? Paternity leave is becoming a day one right, which is removing the current requirement for employees to have 26 weeks of service. Unpaid parental leave is also becoming a day one right, which will remove the current requirement to have 1 year of service before taking that leave. And separate to the Employment Rights Act, but coming into force at the same time, as the other family-friendly reforms in April, is the bereaved parent's paternity leave, which allows a parent to take up to 52 weeks of leave to care for the child if the primary carer of the child unfortunately dies. So this leave has not been available up till now, and whilst it's hoped it's not needed, it will provide that much needed time for the bereaved parent to care for the child in this circumstance. And these are all confirmed to come in from April too. But there are other things that are proposed as well, which are expected from 2027 or at some point within 2027. So the government is also reviewing carers leave, which did actually come into force in April 2024. But at the moment, it is an unpaid leave entitlement, and they are considering introducing paid leave for carers leave. But this is all to be confirmed, so more information to follow. Another one under consideration is bereavement leave. So when introduced, this would be a day one right, allowing employees to take at least 1 week of bereavement leave. It's not known at this point in time if it would be paid leave or not. All of that, again, is still to be confirmed. But at the moment, there's no statutory entitlement to bereavement leave or ordinary bereavement leave. So that would be a new type of leave coming through. There's also going to be an increased entitlement of parental bereavement leave to provide for 2 weeks of statutory bereavement leave for parents who experience pregnancy loss before 24 weeks, as this is not currently covered. And additional protections against dismissal for a pregnant woman when she is pregnant, on maternity, or within 6 months of returning to work, with some exceptions, which again are to be confirmed. It's also likely to cover those on adoption leave and shared parental leave, but it's not yet clear what the exceptions might be. But we're thinking probably in cases of like genuine redundancy, for example, where the business is closing down. But the whole principle behind this proposal in the Employment Rights Act is to enhance job security for those new and expectant mothers. So that is what is changing and what is proposed, and what this means for you as employers then. So more employees will be able to take time away from work, as more people will be entitled to options for leave from their day one of employment. So it could result in a potential increase in short-term absences or unplanned leave, for example, around carers leave or bereavement leave that we were looking at, and plus more people being eligible to take paternity leave and parental leave. It could create an additional strain covering those absences, especially for smaller organisations, which highlights the need for your workforce planning, cross-training, just to ensure that you have adequate cover for work. But this can be seen as an opportunity to review your organisational culture, to embrace family-friendly ways of working and use it as a way to attract and retain talent in the workforce. So actions that you can take now, again, we are advising to review your family-friendly policies to ensure that they reflect the new legislation, for example, removing that requirement for length of service to become eligible. We're also suggesting that you review your systems to ensure that they capture and monitor any leave dates, just ensuring that staff have a simple and easy way to request their leave, for your managers to review it and approve it and manage it across the team, because then they can easily see who's available or who's on leave at any one time. And review your processes around restructures and redundancies in case you need to go through that, just to ensure that they include a safeguard to identify any new or expectant mothers, just so that you can incorporate them into your business plans. And then, as we've mentioned earlier about training your line managers, so ensure that they know about your updated processes for these leave requests, how to handle one from the team, and ensure that managers understand the enhanced protections and manage that process fairly with their team members, including the return to work stage as well. And communicate the updates to staff so that they're aware of their rights in relation to family leave options, how they might request it, and what timeframes that they would need to work within in terms of notifications to their employer. So they were the family-friendly reforms, and moving on to the next one is fire and rehire, also known as dismissal and re-engagement. So what's happening here is a change that means dismissing an employee for a restricted variation will be automatically unfair. So currently, the law allows employers to dismiss and re-engage an employee on new terms where they've been unable to reach agreement to those new terms of employment. Employers have also been able to dismiss employees on old terms and hire new employees on new terms in this circumstance too, where there's been a genuine business reason to do so, and of course a fair process has been followed. However, if you remember, this was highlighted a few years ago through the P&O Ferries case, where many employees were dismissed, losing their jobs and livelihoods, and in favour of hiring new employees on much less favourable terms. So on here it talks about restricted variations, and that refers to terms such as pay, pensions, hours of work, time off, and also the adding the term itself to make a variation in the future without the employee's consent. They will all be classed as restricted variations under this legislation. On the other hand, unrestricted variations refer to things like the place of work, job title and duties, notice periods, and restrictive covenants, meaning that employers could lawfully dismiss an employee for refusing to agree to these kind of changes, with the caveat, of course, of them being reasonable and following that fair process too. The changes to this legislation is also going to introduce a threshold employers must prove in order to fire and rehire, which will include serious financial difficulties affecting the business's ability to continue in business. That the changes to the terms of employment proposed were to mitigate those serious financial problems, and that there were genuinely no other options to take. So all of these factors must be proved by the employer to rely on a dismissal and re-engagement or fire and rehire to be fair. So alongside this, there's also going to be the introduction of a new statutory fairness checklist to determine what may be deemed as a lawful dismissal, i.e. if an employer dismisses an employee for one of those unrestricted variations, a tribunal would want to consider the reason for the variation, the consultation process that they followed, and also whether they had offered anything in return for that change. So these things are confirmed from January 2027. However, there is a consultation on the finer details, and we are waiting for a revised code of practice on this matter as well. So the details under consultation include things like what is classed as pay. For example, some benefits such as car allowance. We want the definition around that so that we can manage this going forward. So that is what's changing in relation to fire and rehire restrictions. But what does this mean for you? So employers will not be able to rely on fire and rehire as a strategy to change terms and conditions of employment unless they can prove they are in that serious financial position. There's going to be increased likelihood of tribunal costs and cases coming through if employers do continue with their previous strategies of fire and rehire, if the outgoing employees then will have a claim for automatic unfair dismissal. And whilst we talk about costs here, it's not just financial costs, but also reputational costs that we see through tribunal cases coming through. There's also an increased burden on employers to prove their financial situation. So employers will face greater scrutiny from tribunals who will want to examine financial evidence and the decision making and the lead up to any dismissals that they may take place. So what can you do now then? So we would advise to review your current terms and conditions in relation to those restricted variations and consider whether you do want to make any changes now and whether you want to push them through before this comes into force in January. There's still a little bit of time. But carrying out the review now will provide you with information on what terms you have in place that fall into those restricted variations, so that at least you know what you have in place at the moment. We're advising to review or implement, if you don't have one, a process for consultation, as you would need a robust consultation process to make any contractual changes going forward. And this includes early engagement with staff, ensuring that your consultations are meaningful as well. And not forgetting here to engage with any employee reps or trade unions where relevant within your organisation. As we've talked about, train your managers in effective consultation processes, and this includes their communication skills, their negotiation skills too. Provide your managers with guidance on handling potentially difficult conversations or objections from employees, and equip your managers with the tools to support a consultation process to try and reach a voluntary agreement as much as possible, such as an incentive to offer in return, which might be an enhancement on some other term like additional holiday or something like that, or more flexibility in their role, or it could be agreeing to make any changes over a phased process and agreeing to keep those under review just in case there are any business changes along that time. But overall, ensure that you have a clear business case for any changes that you need to make and a documented record of the decisions made to get to that point. If the organisation is unfortunately in a serious financial difficulty, then you will need to provide evidence of that, of the financial pressures faced, the alternatives that you've looked at, and the process that you have gone through. And again, all of this is something that we would fully support in terms of our advice here through Impact HR. So if you are in that position, do get in touch with us and we can help you. So moving on to something a little bit less heavy, we're looking at flexible working. There are some changes here coming through expected in 2027. So what's changing to flexible working then? It will become the default option, where employers would be expected to look at how a flexible working request could work in the first instance. So there's going to be more responsibility on employers to approve requests unless they have a valid business reason for refusal. So changes were already made to this back in April 2024 for the right to request flexible working to become a day one right at that point. It also increased the number of requests that employees can make each year from 1 to 2. But this proposal through the Employment Rights Act then is a further step to place that onus on employers to accept the flexible working request as a default position. And if they do have a valid business reason to decline the request, then the idea would be to work backwards from the default position to show how it would not be suitable for that role. So as I mentioned, this is expected at some point in 2027. So we have those implementation dates set out, usually April and October, but we are waiting for the finer details. And we're also waiting for consultations to be completed, which would then hopefully provide an updated code of practice for employers to refer to as guidance of how to manage this process. So what does this mean for employers at the moment then? It could mean increased requests for things like hybrid working, fully remote working, or just varied working patterns. It may potentially create more complications for those managing workforce planning, for covering shifts, for setting rotas, making sure that you have the right people in the right place at the right time. But it may also be seen as an opportunity for organisations to use it as a way to attract and retain talent by promoting flexibility within their workplace. So of course it will be dependent on the type of organisation you are, what sector you are in, what kind of roles you have. But we have seen obviously since COVID that things have changed so much in regards to flexible working options, and the workforce now does have that level of expectation for some kind of flexibility or hybrid working depending on the position. So whilst it's not be coming in until 2027, there are still some things that you can look at now to take some action to prepare for this. So first of all, review your current policies on flexible working and assess whether they are up to date. Since the most recent updates in 2024, which as I mentioned, increased the number of requests employees can make from 1 to 2 per year, but it also reduced the time frame to process a request from start to finish by employers from 3 months to 2 months. And ensure that there are that the policies that you have in place at the moment, ensuring that they're adaptable to the new ways of working when this comes into force next year. Be mindful though that discussions around flexible working may begin during the recruitment stage because it is that day one right. So you might want to reflect this in any recruitment policies that you have too. So it'd be worth having a review of those. We're also advising to assess the capacity to manage flexible working requests against your business continuity and your workload, given that there might be an influx of increased requests. So it would be useful to implement clear processes now and a decision-making framework now for how you handle flexible working requests moving forward. Ensuring that you have clear documentation and a process that is set out for managers to follow should one of their team members submit a flexible working request, so that they know what to do with it and it doesn't sit on a pile for 2 months and then you'll be out of the timescale to deal with this. This review can involve looking at what kinds of flexible working you might have within your organisation. What can you accept or what might not be acceptable? And possibly preparing your business reasons now for responses that might apply across the board for different kinds of role that you have. But obviously you can get these ready, you can prepare them, but don't forget to review each case on a case-by-case basis. And finally, train your line managers on the flexible working policy, on the procedure and the process that they have to follow, just to ensure that that it's set out quite clearly and they know in terms of the process, but also in terms of the time frame, the documentation, and ensuring that you have a strong and robust evidence-based reason to decline any requests should that be the conclusion. So really this is all about looking at changing the mindset around the approach to flexible working requests, rather it being an immediate answer of no to yes, how can we make this work? So you can make use of the tools at your disposal for this process. For example, putting in place a trial period to see how it works and demonstrate that you are willing to give it a go, or try any other options to meet the employee perhaps partway with their request. So that was flexible working updates, and we move now to tribunal reforms and enforcement. So what is changing here? The time limit to bring an employment tribunal claim is increasing to 6 months, and it's increasing from the current 3 months. And don't forget, there could be an extension to this if the employee decides to go through the early conciliation stage, which, as we know, has already increased to 12 weeks as of December last year. So this change to the tribunal timeframe is expected to be in place from October 2026. It's still to be confirmed, but that is the expectation at this moment in time. What else is changing around enforcement is the Fair Work Agency, which is a new organisation who will have powers to bring tribunal proceedings on behalf of workers. And all of this means that there will be a more stringent obligation on employers to for record keeping in order to defend any such claims. And the Fair Work Agency is confirmed to begin from the 7th of April 2026. So this means for employers then that potentially an increased number of tribunal cases and obviously the costs attached to that. With a longer period of time for claims to be raised, employers may be waiting longer to know if they need to defend a case. There's also then going to be that increased requirement for record keeping for the Fair Work Agency on things like holiday pay, leave, shifts, etc., as the requirement is to keep this data for up to 6 years now, which is a significant admin burden on employers. And then enhanced scrutiny by the Fair Work Agency. So prepare for transparency here, as the Fair Work Agency will be reporting on and publishing their work, which means non-compliance would become more visible. So what can you do now to prepare? Review your current processes to ensure that they are compliant to mitigate any potential disputes. How can your current processes be enhanced to foster a more positive working environment to reduce that number of disputes in the first place, but also deal with them quite robustly to resolve them before they escalate? Review your policies to ensure that they are robust in how the organisation handles grievances and things like internal appeal processes, to encourage early resolution of them, again, to reduce the number of complaints that may end up in a tribunal. Train your line managers, again, in handling these disputes, making them aware of the potential risks and how claims might arise. And this can be equipping your line managers with skills to follow a fair process and, again, to document what they do, just to ensure that they put their organisation in the strongest position possible should a tribunal claim come along. Review how your pay and holiday and sick pay data is recorded and stored currently, as the Fair Work Agency will be able to ask you for this data. You want to ensure that the data is kept, first of all, that you know where the data is kept and how it is calculated in the background as well. So we're advising that this is reviewed now, so you can get your data in order in case this is requested by the Fair Work Agency at any point. And if you notice any discrepancies in your data, for example, any underpayments, then you have the chance to correct them now, rather than waiting for a claim to come through from an employee or from the Fair Work Agency. And finally here, you can ensure your systems are set up to store that data, to retrieve that relevant data that may be needed at future points in time, and identify what records you're keeping, how long you're keeping them for, and whether they meet the new standards under the Fair Work Agency. So if you haven't got a system already, consider implementing one or upgrading your current system just to ensure that they support with that data storage and data retrieval and also data reporting. So I mentioned there are lots of changes coming through the Employment Rights Act, and we haven't had time to go through all of them in detail today, but some of the other things that are happening are in relation to trade union reform, which is simplifying the trade union recognition process and making it easier for employees to access trade unions in their organisation, which has already started as of February this year, and more to come. Collective consultation during redundancy. So the protective award available for a collective redundancy process is increasing, and also the review of the threshold of 20 or more redundancies proposed at one establishment is also changing, but that is all to be determined. So more information to come on that one. There are reforms around 0 hours versus guaranteed hours contracts. rights, also gender pay gap and menopause action plans, which is a voluntary action at the moment for employers who have more than 250 employees, but will be becoming mandatory later on. There are updates to sexual harassment in the workplace, requiring employers to take all reasonable steps to prevent sexual harassment, which is an enhancement to what the legislation says currently, as it refers to just reasonable steps. There is protection from harassment, including third-party harassment. And then ethnicity, disability pay gap reporting, again, for those employers who have 250 employees or more, and the extension of equal pay rights around ethnic minority workers and disabled workers, all proposed through the Act, but we don't have a set date as to when these will be coming into force. So as a wrap up of today's session, I wanted to bring everything together really into a clear set of practical next steps for you, things that you can take away into your organisation to try and reduce the risk. So looking at the key action points here, firstly, to review your recruitment and your selection and your probation processes. So these should be structured, they should be consistent and clearly documented from the outset. Having a simple performance review framework in place and ensuring managers are trained to manage performance conversations early, as it will be increasingly important. Reviewing your existing terms and conditions, particularly in light of the tighter restrictions expected around that fire and rehire, dismissal and re-engagement practice. So it's sensible now to consider whether any contractual changes may need to be made now before the restrictions come into force from January. Revisit your approach to flexible working. So with the shift towards flexible working becoming the default position, policies should be updated and organisations should be having a clear decision-making framework in place so that your managers understand how to assess requests fairly and consistently. Review and update your family-friendly policies to reflect the new entitlements. So this includes ensuring your HR systems can accurately record and manage the leave too. That your line managers understand the new rights and processes so that they can support their employees if they put in a request for that kind of leave. Strengthening your consultation processes around employee relations. So ensure that consultation with employees is meaningful, that managers have the tools to seek agreement where possible, and that dispute resolution procedures are clear and well understood. And finally, it's important to recognise that the new legislation will also introduce that additional enforcement through the Fair Work Agency. So this is new for us in the UK. So this means organisations should review their compliance processes really carefully, including their grievance handling, appeals procedures, documentation, record keeping, just to ensure that they can withstand scrutiny if that comes through. So taken together, these actions provide a practical roadmap for you to start those preparations early that will help you stay ahead of the changes, reduce any legal risk and build a more resilient and compliant workplace as the legislation through the Act is coming in over the coming months and years. So after this webinar, you will get a link, as we have done before. It will give you a link to the webinar recording itself, so you can listen back to any sections that might be relevant to you or your organisation. We will also send you a link to our Employment Rights Act checklist, which is very much a summary of what we've talked about today, but is in a nice, handy checklist for you to have out and refer to. And we'll also share our contact details with you should you wish to get in touch with us. And we can discuss any ways in which Impact HR can support your organisation with anything we've talked about today within the Employment Rights Act or HR or employee general queries too. And that was the session. And now we can move on to any questions that might have come through. So I'll hand over to Grace and see if we've had any questions.
We have. So we've had quite a few come through, Juliet. So first one is around fire and rehire. So somebody's asked, does fire and rehire apply when you have a 2P situation if it related to business reasons as opposed to to transfer reasons?
I think that you would have to refer to the 2P regulations more so there. I probably need a little bit more information to answer that question, so I'm not sure if that person wants to get in touch and we can have a chat. But I suppose it depends on the timing of the change, the reasons for the change, because you'd have to link it in with the 2P regulations too. and the restrictions around making changes in that process. So apologies, it was a bit of a brief answer, but probably need a little bit more information on that one.
Okay, brilliant. And also in relation to fire and rehire, is there a list of the restricted variations? I know we kind of spoke about relating to pay and everything like that. Is
Yeah.
there a list available?
Yeah, so we have an indicative list at the moment, which we can provide to you. However, that is one of the points that is going through consultation, and we are waiting for the finer details. Really hoping that we get this soon, because as I said, this comes into force in January, so we do need to know. But yeah, we can provide a list of what we know at the moment, certainly, but hopefully we'll have more detail to come.
Thank you. Another question come through on around tribunal and enforcement reforms. So where you mentioned the time limit to bring an employment tribunal claim will be increasing to 6 months. Is that 6 months minus 1 day? And also does that apply to workers and employees, or just workers, or also
Yeah.
self-employed contractors?
Yeah, so the time frame will work in the same way as it does at the moment. So at the moment, it's the 3 months less 1 day, so it will be the same case, but it'll be 6 months. However, we do need to take into account that it can that the clock can stop during that time frame as well if the employee does go through early conciliation, which obviously is longer now as well. It was 6 weeks and now it's 12. So that actual time frame would again be on a case by case basis, but essentially the employee now could wait 6 months less that 1 day to put in their claim, and it's quite a long time for employers to wait to find out if a claim is coming through.
Thank you. Another one just on the 6 month unfair dismissal rate coming in from January. Obviously, this will lead to more cases for the Employment Tribunal to deal with. Do you know if there's any measurements that the government has proposed to try and sort of take care of the backlog of all the cases that are already in the system and will be coming through?
Yeah, I don't know, to be honest, and this is a really big question that we have, because there's already a backlog that we face. We're seeing claims that are being made and not having a hearing date for up to 2 years. So I don't know the answer to that one, but a really interesting one I would like to go away and find out. So if I do find out, we will share that with you. But I really hope something is done. But I don't know the answer to that one at the moment.
Brilliant. And just a final one, can we still dismiss an employee if they are not working out before 6 months? And also, what is the scenario for after the 6 months? Can you still dismiss an employee then?
Yeah, yes, you can. So before the 6 months, relatively lower risk. It would work the same way it does at the moment for an employee in their first 2 years of employment, just it's going to be a shorter time frame. So you would still need to assess the situation. Are there any other risks involved, any day one rights in relation to automatic unfair dismissal or discrimination issues to take into account. And if they're not, then there's still the option to dismiss within the 6 months, taking into account their notice period as well, making sure it doesn't take them over that 6 month anniversary. And then post 6 months, I think you asked as well. Yes, you still can. This is not a stop at all on any dismissals. It just means that a full and fair process needs to be followed. Again, similar to what we do now for employees who have over 2 years of service. So the option to dismiss an employee is still there. It's just the time frame is a lot shorter for us to manage that before 6 months and after 6 months, in the same way that we do at the moment, before 2 years and after 2 years.
Thank you. Just had another question come through. So, do notice periods change in regards to paid interns?
Um, No, I would assume in that situation, again, might need a bit more information, that statutory notice would apply in that respect, or if you've put something in their agreement, that would then become contractual, whatever is the higher.
Thank you. One more for you, Juliet. So, someone's just asked, so like 103 weeks service to qualify for unfair dismissal currently, will the same rule apply to 6 months less 1 week?
Yes, yes. We have to take into account that statutory week, which again is that the whole thing around making a decision in good time before you get to the 6-month qualifying period. So similarly, like we do at the moment with that 103rd week, we want to make sure that we're within that. We want to be doing that within a week of 6 months. So really, again, setting your probationary period duration is going to be really important. So if you want to set it at 3 months, for example, you're going to have time to make your decision. If things aren't working out, you need a little bit more time, you've got scope to extend it. Or if you set your probation period at 5 months, then you know you must make a decision at that point. It would be really difficult to make a decision up to the last day, because then you are within that statutory week that you need to take account of. So again, works in the same way as it does now for 2 years, but it's going to be at 6 months.
Brilliant. Thank you. That's all the questions for now, so we can move on.
Okay, thank you. And like I say, we'll share our contact details with you. So if you have got any questions, send them over to us. And yeah, whoever asked the first question, please send me a note and we can talk through it a little bit more. And just to wrap up then, we have a final poll for you, just to find out really, just out of interest, what will be your organisation's next step after this webinar? What is going to be your focus now? Is it going to be to review your HR policies and contracts and your documentation, training your line managers on the upcoming changes, seeking HR advice, or just simply continuing to monitor the developments as we go? So it'd be great to see your feedback to this one. That's great, thank you. I think the majority of answers here are reviewing your policies and procedures and your contracts, which is great. That's what we've talked through. There are so many updates to make, but at the same time, not to be overwhelmed with it. Say it's happening in stages, so you have time, and there are that number of changes that are coming in April that I suppose should be the priority there, and then planning it in throughout the rest of the year. So yeah, that's great, thank you. And then just a final highlights before we go of what's available on our website. We have some free resources for you. So one of them is the Employment Rights Act checklist. So we will share a link to that after the webinar. We also have other things like a general HR benchmarking assessment, which is really, really useful to use to audit your function at the moment, and along with things like a sexual harassment risk assessment document too. And within our Impact Hub, you will find this webinar and all of our webinar archive, all of our news and updates. That can be a really useful resource to read through. And then before we finish, just wanted to touch on all of the other things that we do here at Impact HR. We don't just talk about the Employment Rights Act, but we cover the whole spectrum of HR and people management cases. So things like we can support with projects, any restructures or organisational design, proactive things like EDI initiatives, changing terms and conditions, getting information through exit interviews, HR risk assessments, people planning, on all the strategic side of things. We cover the lot. So a big one on here I wanted to mention is that training program. So I mentioned all the way through today, training your line managers just to ensure that they have the skills ready to deal with the Employment Rights Act changes, but also any other people issues that may come along. So we cover all of it, the whole spectrum. So if you need any support, please do get in touch with us. We'd be more than happy to help. And as a reminder, here are our contact details. I hope you have found it useful today. Thank you so much, Grace, for coordinating all the questions in the background and all of the polls. And we hope you have a great day. Thank you.